The morning they fined me $10,000 for my flag was the morning they made the biggest mistake of their lives. I remember the knock like it was a gunshot. Sharp. Deliberate. Meant to intimidate. When I opened the door, the HOA president stood there with her usual tight smile, holding a bright orange envelope as if she were delivering a prize instead of a threat. Behind her, 2 board members lingered on the sidewalk, pretending not to enjoy the moment. She didn't waste time with small talk. "You violated community guidelines," she said, sliding the envelope into my hand. "Immediate compliance required." Inside was a formal notice, $10,000 fine for displaying an unauthorized flag. Unauthorized. The flag in question wasn't offensive. It wasn't political. It wasn't obscene. It was a historic state heritage flag, one that had flown on my grandfather's porch for 30 years. He was a veteran. That flag had been folded at his funeral. And now, apparently, it was worth 10 grand in penalties because the HOA board decided it didn't match the neighborhood aesthetic. I stood there reading the letter twice, then 3 times, waiting for it to make sense. $10,000. Due in 14 days. Or they would place a lien on my home. My home. They must have expected me to fold, to quietly take the flag down and write a check like everyone else they'd bullied before. That's how they operated. Warnings about mailbox colors. Citations for grass half an inch too tall. Threats disguised as community standards. Most neighbors complied out of fear. But this was different. This wasn't about paint shades or lawn ornaments. This was about principle. About history. About the fact that nowhere in the bylaws did it say I couldn't fly that flag. That afternoon, I pulled every HOA document I had. Covenants. Restrictions. Amendments. I read until my eyes burned. And the more I read, the clearer it became, they had overstepped. Badly. By sunset, my anger had transformed into something sharper. Focused. Calculated. If they wanted to play by the rules, I would play better. If they wanted to threaten my home, I would threaten their authority. And if they thought a $10,000 fine would scare me into silence, they were about to learn exactly who they were dealing with. This wasn't going to end with me taking down that flag. It was going to end in court. I didn't sleep that night. The orange notice sat on my kitchen table like it was radioactive. Every time I walked past it, my chest tightened. $10,000 wasn't pocket change. It was mortgage payments. College savings. Emergency funds. And the 14-day deadline ticked in my head like a countdown clock. But fear has a strange way of sharpening focus. By 6 a.m., I had a highlighter in one hand and the HOA governing documents spread across the table like a battlefield map. Covenants, conditions, and restrictions. Architectural guidelines. Amendment logs. I read every line, every comma, every vague phrase they liked to weaponize. The board claimed my flag violated the visual harmony clause. That clause allowed the HOA to regulate exterior modifications that materially disrupt the aesthetic continuity of the community. It sounded official. Powerful. Intimidating. But here's what it didn't say: it didn't mention flags. In fact, buried deep in Section 8.4 was a paragraph stating homeowners retain the right to display historical, governmental, and heritage flags in a respectful manner, subject only to reasonable size limitations. My flag was standard size. Mounted properly. Maintained carefully. They hadn't cited size. They hadn't cited damage. They hadn't cited obstruction. They cited unauthorized. That word wasn't anywhere in the flag provision. That's when I realized something critical. This wasn't an honest mistake. This was selective enforcement. I started making calls. First, my neighbor Tom. He had flown a college flag during football season for years. No fines. No letters. Then Maria down the street she displayed a decorative seasonal banner every month. Again, no citations. By noon, I had photos. Dates. Evidence. The board wasn't enforcing a rule. They were inventing one. And if they were willing to fabricate violations against me, how many others had paid quietly just to avoid trouble? That thought changed everything. This wasn't just about a fine anymore. It was about abuse of power. I scheduled a consultation with the property attorney that afternoon. When I walked into his office and handed him the orange notice, he read it slowly, expression neutral. Then he asked for the bylaws. He read those even more carefully. Finally, he leaned back in his chair and said the words that made my pulse steady for the first time in 24 hours. They don't have the authority to issue this fine under these provisions. I felt something shift inside me. Not relief. Resolve. He explained that HOAs often rely on intimidation because most homeowners don't challenge them. Lawsuits are expensive, time-consuming, stressful. Boards count on silence. But he also said something else. If you fight this properly, not only could you get the fine dismissed, you could challenge the board's pattern of overreach. Challenge the board. Not appeal. Not negotiate. Challenge. That was the moment I stopped thinking defensively. If they wanted $10,000 from me for flying my grandfather's flag, I was going to make them defend every decision they'd ever made. And I was going to do it publicly. By the third day, the fear was gone. In its place was paperwork. My attorney drafted a formal demand letter addressed to the entire HOA board. It wasn't emotional. It wasn't angry. It was surgical. Line by line, it dismantled their claim. It cited Section 8.4. It referenced state property statutes protecting homeowners' rights to display heritage and governmental flags. It demanded immediate withdrawal of the $10,000 fine and warned that continued enforcement would constitute selective discrimination and abuse of authority. At the bottom was a sentence that made me smile for the first time all week. If the board chooses not to rescind this penalty within 7 business days, my client will pursue all available legal remedies. All available legal remedies. We sent it certified mail. Now we waited. The response came faster than I expected. Instead of backing down, the HOA president emailed me directly copying the full board. Her tone was polite, but the message was clear: the fine would stand. She claimed the board had discretionary authority to interpret aesthetic guidelines and insisted my flag was visually disruptive. Visually disruptive. It flew from a standard pole attached to my porch. No profanity. No slogans. No flashing lights. But what truly caught my attention was one line buried in her email. The board's interpretation is final. That's when I knew this wasn't just arrogance. It was overconfidence. Because in reality, HOA boards are not above the law. Their authority exists only within the boundaries of their governing documents and state statutes. Discretion doesn't mean unlimited power. It certainly doesn't mean rewriting provisions to fit personal opinions. My attorney read the email and nodded slowly. They just handed us Exhibit B, he said. We filed a formal internal appeal anyway. Not because we expected fairness, but because procedure matters. Courts care about process. And I was going to follow every step perfectly. The appeal hearing was scheduled for the following Tuesday. When I walked into the clubhouse that evening, the board sat behind a folding table like a panel of judges. The HOA president avoided eye contact. Two members shuffled papers nervously. A handful of neighbors attended, whispering to each other. I presented calmly. I cited the bylaws. I referenced state law. I showed photographs of other flags displayed without penalty. The board deliberated for less than 5 minutes. Appeal denied, the president announced. No explanation. No legal reasoning. Just denied. But here's what they didn't realize: I had recorded the entire hearing, as permitted by law. And in that short 5-minute deliberation, one board member accidentally admitted they had discussed my situation privately before the meeting. A pre-decided outcome. Improper procedure. Conflict of interest. They thought they were closing the door. In reality, they had just opened a much bigger one. The next morning, my attorney filed a lawsuit against the HOA and named every board member individually. If they wanted to claim their interpretation was final, they were about to learn who actually has the final word. The lawsuit changed the tone overnight. What started as an orange envelope taped to my front door had now become a formal complaint filed in county court. The HOA wasn't just defending a fine anymore, they were defending their credibility. And they weren't happy. Within days of being served, the board sent out a community-wide email. It painted me as combative, uncooperative, disruptive to neighborhood harmony. They claimed the lawsuit would cost the association thousands in legal fees, implying that I was the one hurting property values. It was a calculated move. Turn the neighbors against me. Make me the villain. At first, it worked. I noticed the stares when I walked my dog. Conversations that stopped when I approached. One neighbor quietly asked if it was true I was suing everyone. I didn't argue. I didn't gossip. I simply handed over copies of the bylaws and the fine notice when people asked. Facts are louder than rumors. Then something interesting happened. A retired couple from 2 streets over knocked on my door one evening. They brought a folder. Inside were violation notices they'd received over the past 3 years: fines for a garden bench, 4 wind chimes, for a wreath left up too long after the holiday season. They had paid every one of them. We didn't want trouble, the husband admitted. They weren't the only ones. Within a week, 3 more homeowners reached out. Stories started to surface: warnings issued without hearings, fines imposed inconsistently, rules applied to some but ignored for others. The pattern was clear. This wasn't about a flag. It was about control. Meanwhile, the HOA's attorney filed a motion to dismiss the case, arguing that the board had broad discretionary authority and that courts should not interfere in internal governance matters. My attorney responded with documentation, the bylaws, the state statute, the recorded appeal hearing where pre-deliberation was admitted. Selective enforcement. Improper procedure. Abuse of discretion. For the first time, the board had to answer under oath. That's when it became personal for them. One board member resigned within 2 weeks. Quietly. No announcement. Just gone. Another requested separate counsel. Cracks were forming. At the preliminary hearing, the judge denied the motion to dismiss. He stated, on record, that the plaintiff had presented sufficient evidence to proceed to discovery. Discovery. That meant financial records, email communications, internal discussions. Everything. I saw the HOA president in the hallway afterward. Her confidence was gone. In its place was something sharper: worry. Because once discovery began, this case would no longer be about a single flag. It would be about every decision they'd made behind closed doors. And if they thought a $10,000 fine would intimidate me into silence, they were starting to realize it had done the exact opposite. This was no longer just my fight. It was becoming the neighborhood's. Discovery began with a stack of formal requests. Emails between board members. Internal meeting notes. Financial ledgers. Records of violations issued over the past 5 years. My attorney warned me not to expect cooperation. They'll stall, he said. They always do. He was right. The HOA's lawyer objected to nearly everything. Claimed requests were overly broad, irrelevant, unduly burdensome. But the judge had already signaled he wasn't interested in shielding questionable governance. Within weeks, they were ordered to comply. That's when the real story surfaced. The emails were worse than I imagined. One thread showed the HOA president complaining about my flag months before the fine was issued. She wrote that it didn't fit the image we're trying to project. Another board member replied, "We can probably use aesthetic discretion." Probably. There was no mention of violations. No formal complaint. Just personal dislike. Then came the enforcement logs. Dozens of flags displayed throughout the neighborhood, sports teams, seasonal banners, decorative designs. Only one homeowner had been fined. Me. Selective enforcement wasn't speculation anymore. It was documented fact. But what truly changed the case was the financial audit. Buried in the expense reports were repeated legal consultations labeled vaguely as general advisory. Dates matched up with periods when certain homeowners had challenged fines. The board had been using HOA funds community dues to strategize enforcement against individual residents, including me. The deeper we looked, the clearer the pattern became: intimidation funded by the very people being intimidated. When depositions began, the cracks widened. Under oath, one board member admitted they had discussed setting an example to prevent other homeowners from testing boundaries. Another acknowledged they hadn't reviewed the specific flag provision before approving the fine. They assumed authority. They never verified it. The HOA president's deposition was the most telling. When asked whether she had personally disliked the appearance of my flag, she hesitated. Yes, she finally said. When asked whether personal dislike was grounds for financial penalty under the bylaws, she had no answer. Outside the deposition room, she avoided looking at me. The board's attorney shifted tone soon after. Suddenly, there was talk of settlement discussions, of amicable resolution, of moving forward together as a community. But the damage was already public. Neighbors had started attending court hearings. Word had spread about the emails, about the audit, about the depositions. The narrative was changing. This wasn't a stubborn homeowner refusing to comply. This was a board exposed. And the $10,000 fine that started it all? It was beginning to look very small compared to what this case might cost them in the end. The settlement proposal arrived on a Friday afternoon. It was thicker than the original orange envelope but far more careful. The HOA offered to rescind the $10,000 fine immediately. They would also clarify their flag policy moving forward to prevent future misunderstandings. Each side would cover its own legal fees. The matter would remain confidential. Confidential. That word told me everything. They weren't offering peace. They were offering silence. By that point, Discovery had already exposed their private emails and selective enforcement logs. Depositions had been recorded. Neighbors were talking. If this case quietly disappeared, the board could rebuild its image and continue operating with minimal consequences. My attorney laid it out plainly. If you accept, your fine disappears. But so does the leverage to change anything. He wasn't pushing either way. He was stating fact. The easy path was tempting. No more court dates. No more legal bills. No more tension when walking past the clubhouse. But I kept thinking about the retired couple who had paid fines they didn't deserve. About the families who didn't have the resources to hire a lawyer. About the phrase setting an example. They had wanted to make me an example of compliance. Now they were afraid I'd become an example of resistance. We responded with a counter-offer. Rescind the fine. Reimburse my legal fees. Publicly acknowledge improper enforcement. Amend the bylaws to clarify homeowner flag protections. Implement oversight procedures for future violations. In other words, accountability. The board didn't like that. Their attorney warned that continuing litigation would drain association resources. He hinted that a prolonged fight could increase tensions in the community. But tensions were already there. They had created them. Weeks passed without agreement. Then the judge scheduled a mediation session before trial. In that room, across a long table, the full board sat stiffly beside their counsel. For the first time, there were no folding tables or clubhouse authority. Just equal parties in a legal dispute. The mediator asked a simple question: why wasn't this fine withdrawn when concerns were first raised? Silence lingered. Finally, one board member admitted they didn't want to appear weak. There it was. Not legal reasoning. Not community protection. Ego. By the end of mediation, the settlement terms had shifted dramatically. They agreed to reimburse my legal costs. They agreed to formally withdraw the fine. And they agreed to revise enforcement procedures under independent review. But they still resisted one thing: a public statement. That final decision would determine how this story truly ended. The board refused to issue a public apology. They agreed to rescind the fine. They agreed to reimburse my legal fees. They agreed to rewrite enforcement policies. But admitting wrongdoing in writing? That was where they drew the line. Their attorney argued that a public statement could expose the association to future liability. What he really meant was this: once you admit abuse of power, people start asking questions about everything else. The mediator looked at me. You can accept the settlement as is, he said calmly, or you can proceed to trial. Trial meant risk. More time. More stress. Even though the evidence was strong, court is never guaranteed. Judges can surprise you. Juries can misinterpret things. And appeals can drag cases out for years. But something had shifted in me long before that mediation room. This was never just about the money. It was about the narrative. If the case ended quietly, the official story would remain: misunderstanding resolved. No harm done. Board acted in good faith. That wasn't the truth. The truth was that they targeted a homeowner because they didn't like what he displayed. They stretched language in the bylaws to justify it. They pre-deliberated an appeal. They used community funds to intimidate. And when challenged, they tried to silence it. I declined the partial settlement. We moved toward trial. That decision changed everything. Word spread fast. A trial meant testimony under oath, public record. It meant more documents becoming accessible. It meant scrutiny. 2 more board members resigned within a month. An emergency HOA meeting was called to fill vacancies. For the first time in years, turnout was packed. Homeowners stood up during open forum and asked direct questions. Why did we fund legal action against a resident without a full community vote? Why were similar flags never fined? Why wasn't the appeal handled impartially? The remaining board members stumbled through answers. Then something unexpected happened. A motion was introduced from the floor permitted under association rules to initiate a recall vote against the remaining board leadership. The room went silent. A recall vote required signatures. Enough homeowners were already present to start the process immediately. People lined up. Clipboards passed from hand to hand. No shouting. No chaos. Just quiet determination. Within 2 weeks, the recall threshold was met. A formal vote was scheduled. On voting night, the turnout was the highest in the association's history. And when the ballots were counted, the result was decisive. The HOA president was removed. So were the remaining original board members. By the time the trial date arrived, the leadership that fined me no longer held office. But the legal case was still active. And now the new board faced a decision of its own. By the time the trial date approached, the HOA board that fined me no longer existed. In its place was a newly elected group of homeowners, people who had sat quietly in meetings for years but finally decided they'd had enough. They weren't polished. They weren't power hungry. They were cautious, almost uncomfortable with authority. And they walked into their first executive session with one major item on the agenda. My lawsuit. The new board requested a meeting with my attorney before the trial date. Not to intimidate. Not to posture. To understand. I attended that meeting. The atmosphere felt completely different from the folding table hearing months earlier. No arrogance. No rehearsed superiority. Just nervous accountability. One of the new board members spoke first. "We've reviewed the discovery documents," she said. "We don't agree with how this was handled." That was the first time anyone connected to the HOA had said those words aloud. They acknowledged the selective enforcement. They acknowledged procedural mistakes. They acknowledged that community funds had been used aggressively. Then they made an offer. Not a confidential one. They proposed a formal settlement agreement filed with the court public record. It would include full reimbursement of my legal costs, written clarification of the flag provision, and implementation of an oversight policy requiring independent review before fines above a certain amount could be issued. And then they added something unexpected. A public statement to the entire neighborhood recognizing that the prior enforcement action had been improper. Not dramatic. Not emotional. But clear. My attorney looked at me carefully. This was what we had pushed for from the beginning: transparency and structural change. The difference now was intent. This wasn't damage control. It was correction. We finalized the agreement 2 weeks before trial. It was filed in court, ending the case officially. The judge signed off, noting that the resolution addressed both the individual dispute and broader governance concerns. The orange fine? Withdrawn. The $10,000 demand? Nullified. My legal fees? Fully paid. But the most important part wasn't financial. A week later, every homeowner received a letter from the new board. It explained that enforcement procedures had been revised. That future discretionary actions would be reviewed against explicit bylaw language. That community funds would require greater transparency. And yes, it acknowledged that my fine had been improperly issued. No spin. No vague wording. Just facts. For the first time since that knock on my door, the neighborhood felt different. Conversations returned. Tension eased. The retired couple down the street stopped by again, this time smiling. I still fly my grandfather's flag. Same pole. Same size. Same place. Only now, it means something more. Looking back, people still ask me the same question. Was it worth it? On paper, the answer seems simple. The $10,000 fine was erased. My legal fees were reimbursed. The board members who pushed the violation were removed. The rules were clarified. Oversight was implemented. But what it really cost them can't be measured in dollars. It cost them authority without accountability. It cost them the comfort of operating unchecked. It cost them the assumption that no one would fight back. The old board believed something dangerous: that most homeowners are too busy, too intimidated, or too financially cautious to challenge power. And honestly, they weren't entirely wrong. HOAs across the country rely on that calculation every day. But here's what they misjudged. They thought they were fining a flag. They were challenging principle. The moment they decided to set an example, they unknowingly created one. Just not the kind they intended. The recall vote changed how our neighborhood functions. Meetings are now recorded and shared. Enforcement actions require documented justification tied directly to specific bylaw provisions. Legal expenses are itemized transparently in quarterly reports. And something else changed too. People speak up. The retired couple who once paid fines quietly now attend meetings regularly. New homeowners ask questions before signing compliance letters. Board members explain decisions instead of hiding behind vague language. That cultural shift didn't come from anger. It came from exposure. As for the former HOA president, she moved out 6 months later. I don't know if the lawsuit influenced her decision. I don't need to. Accountability has a way of following people, even when courts are finished with them. The day the settlement was finalized, I stood on my porch and looked at that flag again. It still carries my grandfather's memory. It still represents history. But now it represents something else too: boundaries. Not the kind written in restrictive covenants. The kind that define how far authority can go before it must answer to the people it governs. They tried to charge me $10,000 for fabric and color.
In the end, it cost them their position, their reputation, and their control. If there one lesson in all of this, it's simple: read the fine print, know your rights, and never confuse confidence with the legality, because sometimes the smallest act of resistance, like refusing to take down a flag, can universe an entire system of unchecked power. And the exactly what happened.